Okay, good afternoon. Um, my case is Knight versus Jewett. Um, in the case Knight versus Jewett, it set precedent for a lot of cases involving the assumption of risk. The injury in this case occurred January 25th, 1987, and it happened during a halftime of the Super Bowl game when a group of friends decided to play a game of touch football. The plaintiff and the defendant were guests who were invited to watch the Super Bowl game. The plaintiff and defendant were on opposite teams. This was a really like a backyard touch football game. During the game, the plaintiff and the defendant collided into one another during a play that resulted in the plaintiff injuring her finger. Yes, I said her. In this game, there were men and women playing in this backyard game. After 3 surgeries, the injuries that the plaintiff had led to the amputation of one of her fingers. So the plaintiff filed a lawsuit on filed a lawsuit claiming negligence and assault and battery. In this claim, the plaintiff was seeking damages, stating that she asked the defendant to not play so rough. In her argument, there was conflicting stories as to what actually occurred leading up to the injury. The only fact the court could confirm was they collided with one another, causing the injury. The defendant claimed assumption of risk, saying that the plaintiff knew the possible risk of the game before she began playing. The California Supreme Court was forced to begin a discussion about the history and the nature of assumption of risk. The court ruled the basics of negligence claims, and they stated, as a general rule, persons have a duty to use due care to avoid injury to others, and they may be held liable if their careless conduct injures another person. The court then examined the issue of inherent risk of a sport or activity. An inherent risk is one that without those risks, the sport would not exist. So another way of looking at it is you cannot participate in the sport without possibly experiencing the inherent risk of the sport. They also looked at whether the defendant owed a legal duty to protect the plaintiff from a particular risk of harm. Does not turn on the reasonableness or the unreasonableness of the plaintiff's conduct, but rather on the nature of the activity or sport in which the defendant is engaged and the relationship of the defendant and the plaintiff to that activity or sport. The defendant in this case was found not liable to the plaintiff because the defendant's carelessness was a risk of the activity, and the plaintiff assumed the risk under the primary assumption of risk doctrine. So in this case, the implications would be that as an athletic director, you need to make all stakeholders aware of the risk involved in being a spectator of the sport. This would include spectators who might be standing on the sideline of a football game, um, knowing that there's a chance an athlete might leave the field of play and strike a spectator, uh, as well as an object such as a baseball or other objects being used to play the sport, leaving the field and striking a spectator. This would also include athletes needing to be made aware of the risk involved in participating in the sports as well. So athletes cannot go back. For example, an athlete who's playing football cannot go back and file a lawsuit saying that they did not know the risk involved in football. They cannot go back and file that claim if you, the athletic director, make them aware of that and document that. And that is my case, my week 6 case. And thank you for listening.